In this video, we will explore the role and influence of unions in Denmark, focusing on the practical implications for employers operating in or entering the Danish market. Denmark is often described as a highly organised labour market, but it is important to understand that this does not mean rigid or adversarial relations by default. Instead, the Danish model is built on a long-standing tradition of social partnership between employers' organisations and trade unions, underpinned by relatively limited direct labour market legislation. For employers, this means that many of the rules that govern pay, working hours, holidays, and other employment conditions are not primarily set by law, but by collective agreements negotiated between the social partners. As a starting point, employers should be aware that union density in Denmark remains comparatively high by international standards, although it has declined over time. Unions are well established in most sectors, and collective agreements cover a significant portion of the workforce, including many employees who are not union members themselves. This coverage effect occurs because collective agreements often operate at sectoral or industry level, setting a framework that is then implemented at company level. From an employer's perspective, it is therefore essential to map the relevant sector agreements, understand which employer association you may need to join, and assess how these agreements align with your business model, cost structure, and workforce strategy. Another defining feature of the Danish system is the relatively high degree of flexibility in hiring and firing, commonly referred to as flexicurity. Instead of heavy statutory protection against dismissal, employees are protected primarily through collective agreements, notice periods, and the social welfare system. For employers, this can be an advantage in terms of agility and workforce adjustment, but it also implies responsibilities, respecting agreed notice periods, engaging in dialogue with union representatives, and managing redundancies in a way that is transparent, predictable, and consistent with both the letter and spirit of the agreements in place. Employers should not underestimate the soft power dimension of unions in Denmark. Union representatives, often elected as shop stewards at the company level, play a key role in mediating issues between management and employees. They are typically well informed, trained, and supported by their union organisations. When engaged early and constructively, they can facilitate implementation of changes, help communicate difficult messages, and act as a sounding board on employee sentiment. When sidelined or brought in too late, they can quickly mobilise resistance, including industrial action ranging from overtime bans to strikes or sympathy actions, all within a framework that is generally well understood and, importantly, seen as legitimate in Danish society. For international employers used to a more individually oriented labour market, it can be tempting to see union influence as an obstacle to managerial prerogative. In Denmark, however, many successful companies have learned to integrate unions into their operating model as strategic stakeholders. This often means an investment in structured dialogue, regular joint meetings, agreed processes for consultation on major changes, and clarity on how information will be shared. It also means recognising that many issues typically dealt with through internal policies elsewhere, such as working time flexibility, shift patterns, or performance incentives, may need to be discussed in a collective setting, either formally via negotiations or informally via dialogue with shop stewards. From a risk management standpoint, employers must recognise that collective agreements in Denmark are enforceable, and that unions have established mechanisms for resolving disputes. These include local-level discussions, escalation to employer organisations, and ultimately labour courts or arbitration. Compliance is more than a legal question. It is also reputational. Danish media and public opinion tend to be sensitive to stories of employers who are perceived as circumventing collective standards or undercutting agreed terms, especially in sectors with a history of wage pressure or cross-border labour. Consequently, foreign or new employers are well advised to conduct a structured compliance review before commencing operations, including a detailed analysis of applicable agreements, wage floors, overtime rules, and pension or insurance contributions that may be mandated by sector practice. At the same time, employers should understand that there is room for innovation and tailored solutions within the Danish model. Many collective agreements are framework agreements, allowing a degree of local adaptation. Companies that build trust with unions can negotiate local agreements that support new ways of working, productivity initiatives, or flexible work arrangements, as long as core protections are respected. This can be especially relevant in knowledge-intensive sectors, green transition industries, and technology-driven businesses, where new competence needs and work patterns are emerging rapidly. Another critical area for employers to monitor is the development of union influence on broader themes such as diversity and inclusion, upskilling, and sustainability. Danish unions are increasingly active in shaping agendas related to lifelong learning and competence development, often working with employers' organisations to secure funding and frameworks for training and reskilling. For employers, this can be an opportunity to leverage existing schemes and co-financed initiatives, rather than building everything from scratch. Similarly, unions may act as partners in implementing health and safety standards, psychosocial risk management, and work-life balance initiatives, all of which are increasingly scrutinised by regulators, investors, and employees themselves. Looking ahead, employers should anticipate that union influence in Denmark will continue to evolve rather than disappear. While union membership patterns are changing and some younger employees may be less unionised, the institutional role of unions in collective bargaining, dispute resolution, and policy advocacy remains deeply embedded. Political debates, for example around EU directives, platform work, or green transition regulation, often involve unions as key stakeholders. For employers, this means that proactive engagement, rather than a narrow focus on minimising union presence, is likely to yield better long-term outcomes. In practical terms, there are a few immediate actions companies should consider. First, develop an informed view of the relevant union landscape for your sector, including which unions and employer organisations are most active and what collective agreements are standard. Second, assess your current level of compliance and alignment with those agreements, identifying potential gaps in pay, working time, benefits, or consultation processes. Third, establish clear internal governance for union relations. Who in management is accountable, how issues are escalated, and how messages to employee representatives are coordinated. Fourth, invest in capabilities. Train managers, especially line managers and HR business partners, in the specifics of the Danish model, including what they can and cannot negotiate individually and how to constructively involve shop stewards in problem solving. Finally, approach union interaction with a mindset of partnership. This does not mean agreeing to every demand or avoiding firm positions in negotiations, but it does mean being transparent about business objectives, sharing relevant data where appropriate, and explaining the rationale for decisions that affect employment conditions. In the Danish context, credibility and predictability are powerful currencies. Employers who respect the established institutions while using the flexibility inherent in the system to adapt and innovate are typically able to maintain both competitiveness and constructive employee relations. By understanding the real nature of union influence in Denmark, structured, institutionalized, and socially legitimized, employers can move beyond seeing it as a constraint and instead treat it as a framework within which sustainable, high-performance organizations can thrive.